Here is what nobody is reporting. On May 22nd, 2026, the Court of Appeal in Abuja issued a formal stay of proceedings, a binding legal order telling the Federal High Court to halt this exact case. No hearings, no rulings, stand down. On June 15th, 2026, the Federal High Court delivered its judgment anyway. 5 opposition parties deregistered. Atiku Abubakar, who just won the ADC's presidential primary, potentially off the 2027 ballot. Governor Adeleke of Osun, potentially off his own re-election ballot in August. While everyone is debating whether these parties deserved to be deregistered, nobody is asking the one question that changes everything. Can a Federal High Court legally deliver a judgment that an appellate court has already ordered it not to deliver? Because if the answer is no, and there are very serious constitutional lawyers who say it is no, then what we are looking at is not a deregistration. We are looking at a judgment that may be legally void from the moment it was written. Stay with me, this goes much deeper than a court ruling. Before we go further, if you're new here, this channel exists for one reason: to give Southwest Nigeria the political analysis mainstream media won't. Hit subscribe and stay with me. This gets deeper. On Monday, June 15, 2026, Justice Peter Lifu of the Federal High Court in Abuja delivered a judgment in suit number FHC/ABJ/CS/2637/2025. He ordered INEC to deregister 5 political parties: the African Democratic Congress, ADC, Accord Party, Action Alliance, AA, Action People's Party, APP, and Zenith Labour Party, ZLP. His grounds? The parties failed to meet the performance thresholds required under Section 225A of the 1999 Constitution, specifically failing to win at least 25% of votes in any state during a presidential election, or failing to win any elective seat at the federal or state level in the 2023 general elections. Justice Lifu dismissed all preliminary objections from the defendants and ordered INEC not to permit the parties to field candidates in any subsequent elections, including the 2027 general polls. The suit was filed by the Incorporated Trustees of the National Forum of Former Legislators, NFFL, led by Raphael Igbokwe. The original filing dates to December 2025. The NFFL later sought to amend the suit to include additional parties. The amendment itself was challenged, generating an early appellate dispute that produced the stay of proceedings order in May 2026. Here is where it gets significant for Southwest viewers. The ADC has publicly alleged that individuals connected to the President's Chief of Staff championed this litigation. More remarkable still, the Attorney General of the Federation, Lateef Fagbemi, who was listed as the second defendant in the case, crossed the floor to join the plaintiffs in April 2026. The ADC described this switch as an absurdity which sends a signal that is impossible to ignore. The AGF has not publicly explained this reversal. Timing is everything in Nigerian politics. The judgment lands precisely after Atiku Abubakar concluded his ADC presidential primary and emerged as the party's flag bearer for 2027. Accord Party under Adeleke was finalizing re-election strategy for the Osun governorship contest in August 2026, and the broader opposition coalition project, which had spent 18 months using ADC and Accord as consolidation platforms, was at its most structured and funded. Disrupting 5 parties simultaneously at this exact window serves a specific electoral purpose. Whether that purpose is the intent of the court or of the plaintiffs is a question the appellate process must answer, but the timing is not coincidental.
INEC deregistered 74 parties administratively following the 2019 elections under a similar reading of the constitutional threshold. That process was carried out by INEC itself, exercising its own regulatory judgment. This case is structurally different. INEC told the court the ADC was compliant. A court then ordered INEC to deregister a party that its own regulator found to be in good standing. That inversion, court ordering a regulator to act against its own assessment, is without clear precedent in Nigerian electoral law.
Institutions involved. Federal High Court Abuja, Justice Peter Lifu, the originating court. Court of Appeal, Abuja Division, issued the stay of proceedings on May 22, 2026. INEC, respondent, and now the body ordered to execute the deregistration. Office of the Attorney General of the Federation extraordinarily switched from defendant to plaintiff mid-case. National Judicial Council, NJC, where the ADC has announced it will file a misconduct petition against Justice Lifu. Supreme Court, ultimate appellate destination for any matter that runs the full legal course. Section 22(5)(a) of the 1999 Constitution, as amended, gives INEC the power to deregister political parties that fail to meet specific electoral performance benchmarks after a general election cycle. The thresholds: winning at least 25% of votes cast in any state during a presidential election, or winning at least one seat in the National Assembly, or winning at least one seat in any state House of Assembly. The plaintiffs read this as mandatory. If a party fails all three, INEC must deregister. INEC read it as discretionary. The Constitution gives INEC the power to deregister, not an obligation. Justice Lifu sided with the plaintiff's interpretation. That legal question, mandatory or discretionary, is now the central issue on appeal. On May 22, 2026, the Court of Appeal in Abuja granted a stay of proceedings in this case, pending the hearing and determination of an appeal before it. That order was still in effect on June 15. A stay of proceedings is not advisory, it is a binding directive from a superior court. For a federal high court to deliver judgment while a valid appellate stay is in force raises the question of whether the judgment is void ab initio, legally null from the moment of delivery. This is the ADC's strongest legal weapon. It does not require proving that Section 225A was misinterpreted. It requires only establishing that the stay was valid and in force, which the documented Court of Appeal order makes straightforward to prove. The ADC has announced it will lead with this argument on appeal. Beyond the mandatory versus discretionary debate, there is a procedural question about the AGF's role. Nigerian civil procedure does not readily permit a defendant to become a plaintiff in the same procedures without specific court leave. Whether the AGF's April 2026 switch was properly sanctioned by the court and whether any procedural irregularity taints the suit is a live legal question. Additionally, the NFFL sought to amend its original summons to add parties, an amendment that the defendants contested, generating the appellate dispute that triggered the stay. Whether the amendment was validly granted and whether the parties added by amendment were properly before the court gives the appellate courts multiple grounds for intervention short of overturning the constitutional interpretation itself. The most direct beneficiary is President Bola Tinubu and the APC's 2027 re-election machinery. Eliminating ADC eliminates Atiku's chosen platform and disrupts the 18-month opposition coalition building project that had ADC as its structural center. Eliminating Accord removes Adeleke, a sitting Southwest governor, from his August 2026 re-election race and potentially from the 2027 political map entirely. For Tinubu, who is himself a Southwest politician managing delicate relationships across the Yoruba political space, removing Adeleke from a platform where he has grassroots Osun support reduces one of the few credible Southwest voices outside the APC tent. That has direct implications for APC's ability to claim undisputed Southwest dominance ahead of 2027. Atiku Abubakar faces the most immediately visible personal consequence. He has run for the presidency 5 times. He built an ADC strategy specifically because the PDP internal dynamics had become too contested to manage. Forcing him back to PDP, if the ADC re-registration stands, would require re-entering a party structure he chose to leave on terms he may not control. Adeleke's position is uniquely time-pressured. The Osun governorship election is scheduled for August 2026. INEC candidate filing deadlines will close weeks before that election. If the deregistration stands and no injunction is secured in time, Adeleke cannot appear on the ballot on his current platform. His only options are emergency injunction, defection to another party before deadline, or a constitutional challenge that outpaces INEC's administrative calendar. All three carry significant political cost. The Labour Party and NNPP are downstream beneficiaries in an uncomfortable sense. They stand to absorb opposition defectors, but absorbing a defracted coalition is not the same as building one. The consolidation work that ADC represented does not automatically transfer to another platform. We posed this question in Section 2. Why did the Attorney General switch from defendant to plaintiff? The answer that the ADC is asserting, and that has not been publicly refuted, is that the AGF's switch was a signal that the executive arm of government had aligned with the litigation's objectives. An AGF who was defending the status quo of registered opposition parties chose instead to advocate for their removal. Whatever the technical legal explanation for that switch, its political meaning is not ambiguous. A 2027 general election without ADC and Accord as platforms structurally consolidates the opposition's problem, fragmentation. The parties that survive, PDP, LP, NNPP, have not demonstrated the ability to combine behind a single candidate. ADC was the platform designed to enable that combination. Remove the platform and the combination becomes harder by definition. The practical question for Southwest political calculations: if Adeleke is forced off the Accord platform in August 2026 and is seen to lose the Osun governorship as a result, that weakens the entire Southwest opposition is viable narrative heading into 2027. It sends a message to Southwest politicians considering opposition alignment that the cost of stepping outside the APC umbrella can be imposed judicially, not just electorally. Southwest. The deregistration of Accord directly targets the most electorally significant Southwest opposition platform. Adeleke's Osun governorship was the only Southwest state outside APC control. Eliminating it through the courts rather than the ballot carries a specific regional meaning that Southwest voters will read clearly. Northwest-Northeast. Atiku's voter base is not eliminated by deregistering ADC. It is displaced. That displacement, potentially into abstention or into a fragmented multi-party protest vote, could paradoxically reduce the APC's margin in a region where it needs strong turnout. Middle Belt and South-South. ZLP structures in Delta and Rivers and Action Alliance networks across the Middle Belt are collateral casualties. Their displacement adds to the general opposition fragmentation without serving any one party's interests cleanly.
Now, if what I just told you surprises you, drop a comment below. I want to know what you think before we get to the part that changes everything. Governor Adeleke is a sitting state executive. The prospect of a state governor being judicially removed from his re-election ballot, not through an election petition challenging his conduct in office, but through a suit targeting his party's registration status, sets a troubling precedent for federal-state power dynamics. Governors of states that are not APC-controlled derive their bargaining power partly from the credible electoral standing of their parties. Weaken that standing judicially, and you weaken the governor's leverage in Abuja even before the election is held. Osun State's economic development trajectory under Adeleke has been tied to specific federal allocation negotiations and state IGR strategies that depend on a governor who commands political credibility. An Osun governorship election result that is contested or disrupted generates investor uncertainty at the state level. Beyond Osun, the general uncertainty about which parties will be permitted to operate in 2027 delays corporate political risk assessments, a real cost to inward investment planning. At the national level, reduced opposition competition correlates historically with reduced policy accountability pressure. When incumbents face weaker electoral challenges, the empirical record on policy delivery quality across Nigeria and globally is not encouraging.
Political disenfranchisement, particularly where it is perceived as judicially imposed rather than electorally earned, has a documented relationship with instability in Nigerian political history. The ADC's public warning that attempt to manufacture a civilian dictatorship will have consequences for national stability is rhetoric, but it reflects a real phenomenon. Communities that feel their political options have been illegitimately removed tend to redirect their political energy through channels that are harder to predict and manage. The Southwest specifically has recent memory of political grievances metastasizing into security consequences. The responsible analysis is to note that risk, not to predict it. The United States Embassy in Abuja has commented on every major democratic stress point in Nigeria since 1999, the 2023 election disputes, the Naira crisis, the subsidy removal. A court ruling that eliminates 5 opposition parties from electoral participation on the eve of a presidential cycle is precisely the kind of democratic backsliding indicator that triggers formal diplomatic statements. Watch for a U.S. Embassy reaction within 72 hours of INEC's next public move on this. The European Union Election Observation Mission that monitored the 2023 Nigerian elections made specific recommendations about party registration fairness and INEC's regulatory conduct. This ruling provides grounds for the EU to revisit those recommendations publicly, a form of diplomatic pressure that Nigeria's ongoing Eurobond access strategy makes it sensitive to. Yoruba diaspora communities in the United Kingdom, particularly in London and Birmingham, and in the United States, particularly in Houston, Atlanta, and Washington, D.C., were among the most financially and logistically active supporters of Adeleke's 2022 Osun governorship campaign and his 2023 re-election preparations. They contributed financially, organized media amplification, and provided international visibility to his candidacy. What they are watching now is the possibility that their investment and their political voice by proxy has been extinguished not by the Osun electorate, but by a federal high court judgment delivered in defiance of an appellate stay. That is experienced not as a Nigerian legal technicality. It is experienced as confirmation that votes do not determine outcomes and that diaspora political engagement in Nigerian democracy is structurally futile. That feeling, if it solidifies, will have consequences for diaspora remittance patterns, for diaspora political funding in 2027, and for the tone of diaspora community commentary on Nigeria's international standing. These are not trivial consequences. The use of judicial mechanisms to eliminate opposition parties from electoral competition without a direct electoral mandate is not a uniquely Nigerian phenomenon. It has appeared in recent years in contexts as varied as Bangladesh, Hungary, and several post-Soviet states. In each case, the pattern follows a similar logic. Use a technically legal instrument, party registration requirements, electoral performance thresholds, to achieve a political outcome that would be harder to achieve through direct executive action. The international democracy community recognizes this pattern. That recognition creates both a reputational risk for Nigeria and a strategic resource for the affected parties. The intellectually honest version of the argument for deregistration goes like this. Section 225A was added to the Constitution precisely because Nigeria's multi-party system had become overloaded with non-functional parties. Entities that exist on paper, contest elections without genuine voter support, and serve primarily as vehicles for political patronage and strategic defection. A party that fails to win a single seat at any level of government across a 4-year election cycle is, by any reasonable democratic measure, not a genuinely competitive political actor. Keeping such parties registered dilutes the ballot, confuses voters, and preserves platforms for elite political maneuvering rather than genuine democratic participation. Under this reading, Justice Lifu was enforcing a constitutional mandate that INEC had declined to execute out of institutional caution. The plaintiffs had a legitimate grievance. Section 225A exists for a reason. Misconceptions circulating in public discourse. INEC moved against these parties. False. INEC told the court the parties were compliant. This was a court order, not a regulatory decision. Atiku is banned from the 2027 election. Not yet and not necessarily. He can contest on another party's platform. He can win the appeal. The deregistration is not yet final. What is disrupted is his strategy, not necessarily his eligibility. This ruling only affects the opposition. The parties being deregistered span the political spectrum in terms of membership and grassroots structure. The political effect disproportionately hits the opposition, but the legal precedent that a court can order INEC to deregister parties over INEC's own objection creates a tool available to whoever controls the litigation process in the future.
The Southwest has consistently operated from a position of political leverage because it has maintained credible political options outside a single party. That is the structural source of Southwest political bargaining power. Adeleke's Accord governorship in Osun was one of the clearest expressions of that optionality. A legal mechanism that can remove a Southwest governor from his own re-election ballot without a court finding of personal misconduct, without an election petition, and without a single Osun voter casting a vote on the question is a mechanism that diminishes Southwest political optionality. It does not matter which party benefits from Adeleke's removal. What matters is that the mechanism exists and has now been used. The Southwest's strategic interest is not in any specific candidate or party. It is in preserving the conditions under which Southwest political actors can credibly threaten to compete and win outside the ruling party's tent. This ruling is a threat to those conditions. That is the Southwest relevant conclusion. Does Adeleke have a legal path to the August 2026 ballot? The answer depends on one variable: how quickly the Court of Appeal schedules the emergency injunction hearing. If the affected parties secure an appellate order restraining INEC from acting on the deregistration before INEC's candidate filing deadline for the Osun election, which analysts estimate falls in mid to late July, Adeleke remains on the ballot. If the appellate courts move at their normal pace, he does not. The race is now between legal process speed and INEC administrative calendar. That is the most important clock in Nigerian politics right now.
3 most likely next moves. 1. Emergency injunction application. Certain, imminent.
The ADC and Accord will file emergency applications at the Court of Appeal seeking an order restraining INEC from taking any deregistration action pending full appellate hearing. Given the May 22nd stay order that Justice Lifu appears to have ignored, the Court of Appeal has strong institutional incentive to respond quickly and decisively to reassert its authority. 2. NJC misconduct petition against Justice Lifu, announced. The ADC has stated it will petition the National Judicial Council. This is simultaneously a legal strategy and a public legitimacy campaign. It keeps the narrative of judicial hierarchy violation active and puts the NJC under visible pressure to respond to an obvious procedural breach. 3. Political platform hedging, behind the scenes. Atiku's political machinery and Adeleke's team will be quietly exploring contingent platforms in parallel with the legal fight. Labour Party and NNPP are the most discussed alternatives. This hedging will become visible in informal political meetings before the end of July 2026. Watch for signals from party chairmen of LP and NNPP receiving unexpected high-level visits. Signals that would confirm escalation. INEC publishes formal notice of deregistration before an injunction is secured. The Court of Appeal declines to schedule an emergency hearing within 2 weeks. The NJC receives but does not acknowledge the misconduct petition within 30 days. Atiku or Adeleke publicly signals migration to an alternative party platform. Western diplomatic missions issue statements referencing this ruling as a democratic governance concern. The most consequential long-term question is not whether ADC or Accord survive this specific case. It is whether Nigerian politics has normalized a new tool, judicial deregistration of opposition parties, timed to electoral cycles. If this judgment stands, even partially, it establishes that a body of former legislators with sympathetic courts can disrupt the opposition's platform strategy at a moment of maximum vulnerability. That is a capability, once demonstrated, that will be replicated. For the Southwest specifically, the long-term implication is structural. If Accord's deregistration is enforced, and Adeleke loses August's governorship as a collateral consequence, the Southwest will have lost its only APC external governorship. That shifts the entire regional political economy back toward a dependence on APC access that Yoruba political culture has historically resisted.
We opened with a fact. A Court of Appeal order told the Federal High Court to stop. The court did not stop. The question this video posed was, can Atiku and Adeleke still run in 2027? The honest answer is probably yes, if the appellate courts move fast enough and enforce their own authority. But the political damage may already be taking hold, regardless of the legal outcome. Disrupting a candidacy for 6 months while litigation runs its course is itself a form of electoral interference, even if the courts ultimately reverse the ruling. The Southwest's specific conclusion is this: the mechanism used in this case is available to be used again against any Southwest politician who builds a platform outside the APC, against any opposition governor seeking re-election. The question Southwest political actors need to be asking is not whether this specific case resolves in the opposition's favor. It is what institutional reforms would make this kind of litigation as strategy impossible to execute in the future. That is the conversation this channel will continue to have, because Southwest Nigeria's political interests are served by clear analysis, not by cheerleading and not by panic, by clear analysis of where power actually moves and how to position ourselves in response. Drop your take in the comments. I want to know, do you think the appellate courts will move fast enough to protect Adeleke's August ballot position, or is the political damage already done? If this analysis gave you clarity, share it with one person who needs to understand what's really happening. Like, subscribe, and I'll see you in the next one.